Hello, everyone. Welcome to another live session with Parsai, which is me. And today we will talk about the latest developments in the immigration to Canada. And of course, we'll talk about your questions, and I'll try to answer your questions. And if you have some time, because this session will be about an hour, I will also explain a few options in terms of immigration to Canada. Just before everybody join us, my name is Parsai. I'm a regulated Canadian immigration consultant. I teach immigration consulting at Ashton College. I'm the author of this book, 88 Tips on Immigration to Canada, which is the bestseller book on Amazon.ca under the immigration law. You can find out about your purchasing options by visiting any Amazon website. The book is available both in print format and also in the ebook format. And you can basically buy whichever format that you like, and you can of course support us. As you know, on our YouTube channel, we publish videos every Monday, Wednesday, and Friday. So please subscribe to our channel and enable notifications to be notified about the latest videos that we publish. Most of our videos are educational. Some of our videos are about the latest news on immigration to Canada. Hello, Mohammed. Good to see you here. So, without further ado, let's talk about the latest developments in the world of immigration. So the government of Canada intends to make sure that people who come to Canada, they won't become inadmissible because of their medical expenses. So for those of you who are not familiar with the concept of medical inadmissibility to Canada, when somebody is immigrating to Canada, they need to show that they are not inadmissible to Canada. And there are so many different reasons or grounds of inadmissibility to Canada. One of those reasons is inadmissibility because of health grounds. So a person could become inadmissible to Canada on health grounds. It means that the person will make Canadians sick or put their lives in danger if that person comes to Canada, or puts excessive demand on our medical system. So what do I mean by that? Of course, if you want to know the details, you have to look at Section 38 of the Immigration Act. But basically, the inadmissibility on health grounds because of safety reasons is when somebody has a disease that disease could put the lives of Canadians in danger. And currently there are only 2 diseases that are identified under Section 38 of the Immigration Act. One of them is an untreated syphilis, and the other one is an active or positive case of tuberculosis, pulmonary tuberculosis, or TB. These are the 2 ones that make you inadmissible to Canada. Of course, if somebody is suffering from a contagious, serious disease, they need to make sure they address that even before thinking about immigration to Canada. The other area is that when somebody, by immigrating to Canada, they put the safety of Canadians in danger because of medical issues. Most of the cases that people become inadmissible to Canada for that specific reason are the people that they are suffering from certain mental disorders. Not every mental disorder make a person inadmissible to Canada. So for example, somebody who is suffering from, let's say, depression or anxiety, they won't become inadmissible to Canada. However, some mental disorders, for example, some psychopathic disorders, they could result in admissibility to Canada. Generally speaking, we're talking about those mental disorders that cause a person to harm others. An example would be somebody who is heavily addictive to drinking and driving, and that person has multiple cases of DUI or driving under influence accusations, then that person or charges or convictions in their home country, that person could become inadmissible to Canada because they think this person cannot change their habits. If they come to Canada, they put the lives of people in danger. Of course, a person who has a DOI could also become inadmissible to Canada under criminality issues. But beside that, the health issues could be another reason. So these two reasons are valid. Everybody understands that. We respect it. We want to make sure that Canadians are safe if somebody is immigrating to Canada. Having said that, we have the third option, and that third option is called excessive demand. So in Canada, we have something called a universal healthcare system. The universal healthcare system offers free healthcare to Canadians. Of course, the exact areas that are free depends on the province that you live in, because the policies of province decide which services you receive for free, which services you have to pay for them. But generally speaking, all the areas that are significant in terms of healthcare, they are free, like visiting your family doctor, visiting a specialist, going through a surgery, your visits to hospitals. You don't pay anything when you go to hospitals, and so on and so forth. There are some areas that they might be free in some provinces, they may not be free in other provinces, but generally speaking, many of the healthcare aspects are free in provinces. If somebody is trying to come to Canada, and when they are coming to Canada as a permanent resident, so they are immigrating to Canada, and that person has a medical problem, that medical problem could cause excessive demand on our universal healthcare system. By excessive demand, it means that either it will be a very expensive undertaking for our healthcare system to take care of that person, or because of the disease that that person has, it increases the wait times for Canadians to receive healthcare. And by increasing the wait times, it causes an increase in the rate of mortality or morbidity among Canadians. Because of those situations, a person could become inadmissible to Canada. However, for excessive demand, the government of Canada has some clear-cut definitions. So, for example, they say, if they have a threshold, and based on that threshold, they say this is the average amount that we spend on every Canadian in Canada for their healthcare system. So if your expenses is above that threshold, then you become inadmissible to Canada. There are some exceptions to the rule of excessive demand. For example, if you are a refugee in Canada, you're exempt from excessive demand requirements. If you're sponsoring your spouse or child, that child or spouse is exempt from excessive demand in Canada. But the rest of people, they need to meet the requirements of excessive demand. So up until 2018, the threshold was roughly around $6,400 per year, which they calculated that for a period of 5 years. That is almost $33,000 for 5 years. So if they found out that your expenses, medical expenses, were more than $33,000 for the next 5 years, that's when you could become inadmissible to Canada on their medical grounds. Of course, they sent you something called a PFL, or Procedure of Fairness letter. You had to respond to that PFL, and depending on your response, I don't want to go into the details of that. I can talk about those details probably for 6 hours. Hi, Andy. Good to see you here. Hi, Tarek. I will answer your question after I'm done with this. So the whole process of how you go through the excessive demand issue is actually the PFL. Sorry, when you receive the PFL, it could take, I can talk about it probably for hours. I don't want to go into the details of that, but it's a huge hassle if you receive one of those PFLs, because you need to prepare documentation, respond to the concerns of the officer, and you could, in some cases, resolve the issue. If you don't, then you could alternatively ask for temporary resident permit or immigration under humanitarian and compassionate considerations, again, depending on your situation. Having said that, the government of Canada decided to increase that threshold in 2018, and they increased it by 3 times. So in that year, it was the excessive demand threshold for 5 years was roughly $99,000. Right now, the threshold is slightly over $100,000. This means that if your medical expenses are projected to be less than $100,000 in the next 5 years, then you won't become inadmissible on medical grounds because of excessive demand. Still, if those first 2 issues apply to a person, you become inadmissible, and there is not an easy work around those issues. Of course, for TB and syphilis, if somebody seeks treatment, then they may immigrate to Canada, but for medical inadmissibility on security grounds, or safety grounds, it's so difficult to go around them. But anyways, the excessive demand changes, or the threshold changes, in fact, resolved inadmissibility for about 70% of people who were considered inadmissible to Canada because of medical grounds before 2018. So after 2018, roughly about 70% of people who used to be inadmissible on excessive demand, they are not inadmissible on excessive demand anymore. And this is great news for immigrants. The plan by the government of Canada is eventually to remove the excessive demand requirements. Right now, that's not the case. But to move towards that goal, they decided to make this permanent. So right now, the government of Canada has made the changes to threshold permanent. It means that we shouldn't be worried about a threshold anymore. The threshold is definitely 3 times of the normal threshold. That means, roughly speaking, around $20,000 per year, or around $100,000, actually slightly more than $100,000 right now, for 5 years. So if somebody is facing medical inadmissibility to Canada, don't freak out. There are solutions around that. I have dealt with medical inadmissibility in the past. And if you have any issues in terms of medical inadmissibility, if you have received a PFL, you can get in touch with me. Even if you have an immigration consultant or lawyer who is helping you, they can consider co-counseling with me. Because I have gone through training for this. I have done some medical inadmissibility cases in the past, and that could help me to assist them with your case. So that's about the news. So again, I repeat, the news is that the government of Canada made it permanent, that the threshold for medical inadmissibility is now 3 times of the normal expenses, which is great news for those people who want to immigrate to Canada and they are facing medical inadmissibility. Okay, so we have 2 questions, I guess. So let me explain those 2 questions, answer those 2 questions. If there are more questions, I will answer them. Otherwise, we will talk about immigration options to Canada. Oh, by the way, the Manitoba government, they actually invited 243 people to immigrate to Canada. So if you have applied under Manitoba immigration programs, it's not a bad idea if you check out your online account to see if you have been invited or not. Of course, you should have received an email, but if you haven't, it's worth it. You should double check your account, because they invited 240 something people, I think 243. Okay, so when will IRCC work at, so this question is from Tariq Bedar. When will IRCC work at full capacity, specifically for economic class? Well, I don't know if anybody knows the answer to this question. I wish I did. And the answer is very complicated because many of the offices of IRCC are located in different countries, and the policies of different countries are different towards the working capacity of different organizations. And it's not just about the local policies, it's also about how dire the situation is in terms of medical issues. For example, I know that IRCC has shut down at least one of their offices in Mexico, actually their main office in Mexico City, just because of the concerns of the issues with coronavirus in Mexico, which is probably the second or third worst country in terms of right now, in terms of handling at least among those that they reported, among handling COVID-19 situation. In some of the overseas offices, like in Singapore, that's not the case. They are heavily, everything is under control, so they are fully operational in those areas. In India, they are half operational. I mean, Delhi works, but not fully. And then other offices in India are also kind of working. For example, in Mexico, visa application centers are closed, and now my clients cannot go through their biometrics when they apply. Either they need to go to the United States to do their biometrics, and of course not everybody has a visa to the United States, and it's an expensive process for them. So that's why it's very difficult to predict that. It depends on the local policies of those governments, that there is a visa office in that country. It depends on the internal policies of IRCC. But in terms of Canada, if we look at Canada and how everything will evolve, of course, nobody can, and I'm not excluded, we cannot predict exactly when internal offices will be fully operational. But I would say, because the vaccination is going very well in Canada right now, it wasn't in the beginning, but now it's going very well. For example, in Ontario, more than 100,000 people are receiving vaccination every single day. So my hope is that by the end of May or maybe mid-July, June, pretty much everybody who qualifies for vaccine and or who wants to receive a vaccine, not who qualifies, they will probably receive their first dose of vaccination, and hopefully by the end of July or by the end of August, everybody will also receive their second dose of vaccination. Of course, there are some people that are against vaccination, so they won't receive their vaccination. But at least the population that is going, that are accepting vaccination, they will hopefully receive their first dose probably by mid-June or end of June, and their second dose probably by mid-August or end of August. So we should see some normalcy in our lives probably in September. And that will, of course, affect IRCC method of processing applications, especially economic applications. We are worried about startup visas, about federal self-employed class, and about express entry when it comes to federal skilled worker class and federal skilled trades class. None of those are being processed properly. And even PNP applications, if you have received approval from the province, you have received your certificate of nomination, and you submit your application today for immigration authorities, it will take a long time to process them. I give you an example. I had a simple certificate of citizenship application. We submitted that certificate of application by the end of November 2019. The processing time at that time was only 5.5 months. And so we were expecting to receive the results by the end of March. And guess what? In March of 2020, we encountered the closures of the CIO Central Intake Office in Sydney, Nova Scotia. And what happened? We received those certificates just last week. So something that was presumably was taking only 5.5 months or even less, it took more than or around 1.5 years. So unfortunately, right now the processing times, most of the processing times are taking a lot longer than we expect. Even with work permit applications, we have so many clients that the work permit applications qualify for 2-week processing, but regardless, we have some of those applications being processed for a few months and no response yet. Okay, so Negars Muzaffari, good morning. Would you please explain about the ICT program? Do you do it in your office? So the answer to your second question is yes, we do it. So ICT depends on, so for those of you who don't know what ICT is, ICT refers to intra-company transfer, and it depends on which nationality you are. So if you are an American citizen or if you are a Mexican citizen, then ICT falls under CUSMA or Canada, US, Mexico agreement, which used to be called NAFTA. And that falls under code T424. And yes, we do that. This is a pretty routine relationship between Mexico, United States, and Canada. If somebody is being transferred from their work from American branch or from their Mexican branch, if that person is a Mexican citizen or an American citizen, they must be an American citizen or Mexican citizen, then we can transfer them to Canada. The kind of jobs that are covered are only senior management jobs, functional jobs, and people with, functional management jobs, CEOs, and also people with a specialized knowledge, which has a specific definition. The duration of work permit depends on whether this is a startup in Canada or not. And also, of course, we need to make sure that we have a subsidiary of that American company or Mexican company inside Canada, or the main branch is inside Canada, the subsidiary in Mexico or in the United States, and so on and so forth. Now, I don't want to go into the details. The intra-company transfer is a very detailed process, and it has so many different aspects. I think the guidelines on IRCC website go beyond just 1 or 2 pages. It's actually very detailed, and the way that officers process those applications are different. On top of CUSMA, we also have some mutual agreements with certain countries. We call them FTA, or Free Trade Agreement. For example, we have an FTA with Colombia for ICT. We have an FTA with Peru for ICT. We have an FTA with South Korea for ICT, and so on. Oh, with Bermuda for ICT. We recently is probably a stretch. Now it's more than 1 year. We have an agreement with called CETA, which is the agreement between Canada and European Union. So if somebody is from the European Union, then they could apply under ICT under the codes of CETA. And then we do have the agreements with now recently Trans-Pacific agreement with a few countries for ICT. If somebody cannot apply under any of those FTAs or CUSMA or CETA or Trans-Pacific agreement, then they could fall under the WTO or World Trade Organization exemptions, which they are defined under GATS, or General Agreement for Trades and Services. And if somebody can apply under that, then we apply for them under code C12, which is an agreement under, again, under GATS to apply. If somebody doesn't even belong to WTO, we still can apply under C12, but our job is more difficult because now proving that we are dealing with an international company that really wants to transfer their employees to Canada, this is a legitimate request. It makes it more complicated. But generally speaking, under the ICT programs, now there are variations. So depending on whether you're applying under CUSMA or CETA or GATS or generic, the situations are slightly different. But at the end of the day, we're talking about an international business that has a branch or mother company or the subsidiary in Canada. We clearly need to show the relationship between these two companies, and they are transferring one of their key employees to Canada. Depending on whether that business is already running in Canada or a startup, the duration of visa could be different. For startups, normally the duration of visa is only 1 year, but for those ones that are not startups, it could be 3 years. And then depending on the position that we are dealing with and the nature of the business, we could extend the work permits up to 5 years, or in some cases up to 7 years. So that's a very quick. I can actually run a course on ICT, and as I mentioned, we definitely do ICT if somebody is interested. We can help them, even if it comes with the business side of the transfer. We do have tools to make it happen. Okay, so next question is by Vixie. So Vixie Nur Hayati. Is a self-employed path still open? I'm self-employed translator for the last 13 years. I'm over 48. I don't think to taking a postgraduate diploma is favorable to me. Okay, so generally speaking, Vixie, yes, of course it is open, okay, but don't get too excited. Let me explain it to you. First of all, federal self-employed class is probably one of the most difficult application processes to Canada. And the reason that it is difficult, because the government is so ambiguous about it, okay? And I have dealt with, from the inception of my job, I have dealt with federal self-employed class. And I can tell you, I've had well over 500 clients under this program from so many different countries. And I can tell you that the main problem with federal self-employed class is the ambiguity of federal self-employed class. The issue is that you need to prove your experience, you need to show that you have the intent and ability to work in Canada, and you need to show that you will make, when you come to Canada, significant contributions to our economy. The problem is that with the exception of the first one, the other two, they don't have any specific definitions. For example, they don't tell you whether you need to take an IELTS test or not. Of course, it's not mandatory. You only lose points if you don't take the IELTS test. But they also don't go into the details to tell you, do they really require English language understanding or not? Having said that, I've never had a client that they were refused because of English language test. I had one case that was refused, and the officer also, among other things, mentioned that I doubt that this person knows English well. But generally speaking, there are so many ambiguities around that. If somebody is from Iran, if you are from Turkey, if you are from Azerbaijan, and I think a couple of other countries, your applications will end up in a visa office called Visa Office in Warsaw. So it's a visa office that is located in Poland. And right now, the visa office in Poland, unfortunately, refuses the applications in mass numbers. They pretty much refuse every single application that they receive. We have a court case against them, judicial review case that is ongoing. We haven't had a hearing yet. But what we are hoping is that after we have the hearing, not only those refused cases will receive their permanent residency, hopefully, but more importantly, for the rest of the population, eventually court will help us to have a clear-cut definition about self-employed application and what are the exact requirements. And this is the demand that I have made to the government of Canada. This is the request that I've made to the government of Canada several years ago. In fact, to the point that even in January 2018, I posted a petition. More than 1,000 people signed it, and I submitted that to the minister. And I asked them, please come up with some clear-cut criteria, and based on that, evaluate those people. Okay, so I said all the negative things. Now, the positive things is that if you are not from those countries, that you will end up in Warsaw. The rest of the visa offices seems to be reasonable in terms of processing those applications. I have dealt with other visa offices, like I have dealt with the visa office in Rome, in Paris, visa office in Singapore, and visa office in Ankara, and those visa offices process their applications more reasonably. If you want to get in touch with us, we can evaluate you to see if you meet the requirements, and then if you do, then we will tell you how to apply for immigration under federal self-employed class. But federal self-employed class is only limited to people in the field of cultural activities or athletics, not beyond that. Okay, so the next question is, Nagar says, I'm talking about ICT from Iran. So Iran, Nagar, the problem with Iran is that Iran is not a member of any of those treaties that I mentioned to you, but we still can apply under code C12, and we do apply for them. It's just that they, honestly, with the Iranian clients, my first problem is that they don't have an many of them, not all of them. Many of them did not have a quite good understanding of international business. And then when we move forward with the C12, we encounter so many hurdles in terms of proving that these two companies are interrelated. But if they do, yes, of course we can do that. Yeah. So Jack Randall, I'm doing the FSC application. It takes some serious patience. It certainly does. It does. So Mohammed Sohail says, I'm sorry for asking you again. Can you restore his status and renew his work permit using only one application? I don't know what you are exactly talking about. So I just, after good morning, you say, can you restore his status and renew his work permit? Oh, okay. So I think you're talking about people who are inside Canada. Yes, the simple answer is yes. When we apply for restoration of status, we say restoration of status. So either we are restoring the visitor status, or the worker status, or the student status. So it is a possibility, and especially right now we have a public policy by IRCC because of the COVID-19 situation, that they are a lot more flexible in terms of applying for restoration of status. The issue that you need to know is that unfortunately restoration of status takes a very, very long time. So it's not an easy thing to get a quick response from the government. So Atizaz Ati, salam brother, salam. Good to see you here. So Vixie says, I'm from Indonesia. If you're from Indonesia, your application will most likely end up in Singapore. And for federal self-employed class, Singapore has been the best so far, my #1 favorite in terms of processing those applications, partly because what they do, they have the habit of interviewing the people. And that makes my job a lot easier, because when they interview you and you literally talk to them in person, then your chances of being approved are very higher. Again, it's not guaranteed that you will be processed in Singapore, but it's very likely. And my experience with Singapore has been very good so far. But again, how you prepare your application, I can assure you, you cannot find any source online that will tell you how to prepare this application. And the way that we prepare our applications is based on more than 10 years of experience with these applications. Believe it or not, we've had hundreds of hours of internal meetings about these applications. We have worked on the processes. I have received so many ATIP requests, submitted so many ATIP requests and GCMS records on these applications, whether about my clients or generically about how the department processes those applications. There is nobody in terms of, and this is a huge claim that I make, but probably there is no one in the field of immigration that knows more than me about federal self-employed class. There are in other areas, there are great immigration consultants, and they know much better than me, but in this area is my territory. I have actually delivered CPD courses for other immigration consultants, and CPD means continuing professional division, just in the field of federal self-employed class in the past. So if you're interested, get in touch with us. Let us evaluate you, because as when we evaluate you, we may say you don't even meet the requirements. If we find out that you don't meet the requirements, we won't even bother to take your case. But if we find out that you meet the requirements, then we will tell you how to move forward. Okay, Citalil Cruz. If get job offer from Quebec while waiting for express entry to be approved, would this impact my application positively or negatively? So it depends. I mean, if you receive the job offer just to work in Quebec on a work permit application, then not necessarily. However, the officers may question your motives, because when you're applying under federal programs, you are claiming that your intention is to settle anywhere but Quebec. So if you are currently working in Quebec, then the question is that why on earth, when you become a permanent resident of Canada, you suddenly say, okay, let's leave Quebec. I don't want to stay here, So that's something that they will question, but does not necessarily result in the refusal of the application. However, if your job offer that you receive from Quebec is to support your express entry application, then this is a definitely no, because you are telling the immigration authorities something that basically, if I become a permanent resident of Canada, my intention is to settle in the province of Quebec, which is against the requirements of express entry applications. So generally speaking, never mix up federal immigration with Quebec in any shape and form. I've had clients in the past that my client was an international student in Quebec, and they applied for a federal immigration option. It was actually a federal self-employed class immigration option. And despite being an international student in Quebec, the government approved the application. They didn't even question that, why you're studying in Quebec. But in terms of work permit, I think generally speaking, again, remember, this is not immigration advice. This video, these live sessions, it's very generic. I don't know the specifics of your case, but generally speaking, to me, combining a work permit in Quebec with a federal immigration is entering a danger zone. And you have so many questions to answer, unless the officer doesn't care. Okay, so the next one, Vixie, may I know how to contact you? Oh, of course, Vicky. Vixie, I'm so easy to find. Actually, just go on our website, settler.ca. There's an assessment form you can, and I just typed it in here. Just go on settler.ca. I don't know if you watched my latest video about authors and translators immigrating to Canada. If you look at the bottom of that video, there is an actual link that you can fill out the form. There's a form that says, if you are a self-employed person, fill out this form and get in touch with us. Okay, so you can just use one of those tools to get in touch with us. So Kwame Robert says, I'm from Cameroon. Wow, that's amazing. Good to see you. I've had some people from Cameroon that they contacted me, but they never hired me. So it's one of those those countries that are not on my list. So far, I've had the honor of representing people who either resided or they were citizens of 50 different countries. But unfortunately, Cameroon is not one of them. So Ati says, my wife file is in London office, January 8, 2020, still not any news what I have to do. So basically, first of all, I cannot offer immigration advice here because I don't know about the specifics of your file. And I may say something and it may turn against you, so be careful. But generally speaking, if you have a file stuck in one of the visa offices, you can communicate with them and ask them questions through the IRCC web form. Okay, so I have a video about IRCC web form. Actually, it's not one of my favorite videos, but in terms of the way I present it, not in terms of the content. The content is really good. But interestingly enough, it's probably the most popular video about IRCC web form. So if you just look up IRCC web form, watch my video, step by step, I explain how you can fill out an IRCC web form and get in touch with the visa office in London and ask them your questions if you're worried about the processing time. Keep that in mind. The processing time for sponsorship applications is elongated, so it's not as regular processing time as it used to be. But again, at the end of the day, you can get in touch with them and ask them your questions. If they reply back to you, they will tell you if they have an estimate in terms of when they are processing the application. Of course, if you want to hire a professional, what we can do, you can get in touch with us. We can submit an ATIP request on your behalf, and then I will read that ATIP request to see what's going on with that file. I'll give you a report. That's an official report about the content of your file. But if you just want a simple interaction with the immigration authorities and ask them questions, just get in touch with them and ask the question. You don't need to hire us. We charge $100 for an ATIP request service. So the next question, please. I wish to ask, my mother is 51 and my younger brother is, so this is from Kuawo. Let's see if we can make our first client from Cameroon. Let's see. So I wish to ask, my mother is 51 and my younger brother is 13 and my sister is 10. I don't know if it's possible for them to immigrate to Canada and which type of progress, please. So based on the age, obviously we cannot come up with a solution. And we need to look into many different factors, for example, education, skills, how much money do you have, the knowledge of English or French languages, and so many other things. Whether that person has a job offer in Canada and what's their intention, studying in Canada, working in Canada, immigrating to Canada. So my recommendation to you is that for the people who want to immigrate to Canada, just go on settler.ca. We have an assessment form. And if you fill out that assessment form, then I think the shortcut to our assessment form is settler.ca/AF. But let me make sure. Just give me a second. Let me make sure that the address is correct. So if you just type this settler.ca/AF. AF stands for assessment form. Then you will see the assessment form, fill out the assessment form, and then we will look at it. If you find that, and it's free service, if we find an opportunity for you, we will get in touch with you. If we don't find an opportunity for you, we won't contact you. But at least after 4 or 5 days or a maximum of 10 days, you will find out if we could find an opportunity for you or not. Sanga Amul, hello. So Tariq says, I have applied for self-employed and I received a temp number. How long it will take to get the permanent, and why did IRCC increase the processing time to 34 months? So Tariq, the simple answer is that nobody knows the answer to your first question. I also have many clients on their federal self-employed class and other programs that they receive temporary file numbers and they have not received a permanent number. The temporary file number is just an acknowledgement of receipt of your application. This means that an officer has not reviewed your package to see whether the documents are complete or not. They will issue a final number when they make sure that your package is complete. If they don't find your package is complete, they will return it back to you. So you either eventually will receive a final number, or you will receive your whole package back. Hopefully the second won't happen. And then from that point, you have to wait for them to process your application. And again, I don't know how much you know about federal self-employed class, but I've seen this over and over again, that majority of people who apply on their own, they get refused, not because they are doing anything wrong, because it's a complicated process. Again, it's up to you, but my suggestion is that you also get in touch with a professional to review your application. If you already have an immigration consultant and lawyer, then good for you. Okay, so the next question is from Sanga Ammo. Is NOC level B job required if wife is on postgraduate work permit and husband is on study permit in Canada, and to convert study permit to open work permit? Well, I didn't get your question. I don't see any relationship between converting your study permit to work permit to the type of job offer that you receive. It depends. So for generally speaking, for work permit applications, the government of Canada does not specify which NOC code, because it depends on the job offer that you receive, and of course whether it's a high wage job or low wage job, and when you go through the LMIA process, etc. So that's a generic one. You cannot convert a study permit to an open work permit. This option by default does not exist. Okay, there are some exceptions that you can convert an open, you can receive an open work permit while you are on a study permit. For example, one of them is the destitute student option, which means that a student is here in Canada and something extreme and unexpected happens to him or her or his family or her family, and because of that they cannot take care of their expenses in Canada. In those situations, they can apply for an open work permit as a destitute student. There are very strict rules around destitute students, but since COVID-19, many students qualified for destitute students. So that's one option. The other option for open work permit is that when you complete your studies and you qualify for postgraduate work permit, which has nothing to do with the NOC code. In fact, the open work permit never has anything with the NOC code, because open work permit is open. It means that you can work for any employer. So it's not limited to NOC code. So again, it's your question is a bit ambiguous for me. But generally speaking, for work permit, there is no NOC requirements. Having said that, because NOC C, NOC D jobs, mostly they fall under low-skilled worker, then it's so difficult to get a work permit for them. But it is a possibility, it's not prohibited. And especially because we have special provisions for agricultural workers, for seasonal agricultural workers, for caregivers, etc., that allow us to apply for work permits for them. But generally speaking, I didn't quite get your question, to be honest with you. Okay, so Brian, hello, Brian. In express entry application, are there any signs that R10 or eligibility is passed? I could request GCMS notes, but it takes a month and won't really do anything for APP, so they are signed. So basically, for those people who don't know what R10 is, it talks about when they consider the application is completely received. So by default, for express entry, they consider that the application is completely received when you receive your ITA. You upload all the documents, you submit the application, and you also pay the processing fee and everything else. So when you make that submission, in a matter of a couple of hours or maybe 24 hours max, you receive a letter, and that letter is your AOR letter as well, and they say we have received your complete package. And they, by default, they consider that as receiving the complete package. That means that at that moment, you qualify for for example, of course, depending on the case, but you qualify for BOWP or Bridging Open Work Permit, okay? So that's the normal behavior. And even if you go on IRCC website with the guidelines for immigration consultants and other people, for the immigration officers, sorry, and other people, you will see that they have mentioned this is the requirement for R10. So it's not like in the past, because in the past, when I submitted a Canadian Experience class, when they introduced Canadian Experience class, when we submitted the Canadian Experience class application, we had to wait for the immigration officer to send me a letter that letter said you are approved in principle. Okay, or for example, for inland cases for spousal, we had to submit the application, wait for the letter that says you have been approved in principle, and at that moment we could apply for the work permit for a spouse or for bridging work permit for Canadian Experience class. That policy has shifted with express entry application, because the expectation is that when you submit the application, pay the fees, because there are specific slots, you cannot miss a slot and not to upload the application, is that you have met the requirement and you can apply for bridging open work permit if that's the case for you. Now, if you want to be on the safe side, super safe side, you can of course apply for for an ATIP request to know. And again, I emphasize more than anything else that do not consider what I said right now as official immigration advice, because I don't know about the specifics of your case. This is a generic answer to this question. Depending on the specifics of your case, the situation could be different. For example, I've seen with many novice immigration consultants or people who are submitting their application on their own, although they fill the slots, but they are not correctly filled the slots, and that creates complications with their express entry applications. But generally speaking, that's the way that they treat it. Okay, so the next question is by Aryan Casey. Hi there, I'm a student at Ashton College. Oh, awesome. Currently in IMCD 06, your videos have really helped me along the way so far, and I was wondering if we'd have the opportunity to have you as our teacher. So Aryan, general answer to your question, it depends on Ashton policies. They assign, I can teach limited number of courses because I run a full-time business, and usually I take only one course at a time. So starting from April 20th, I'm going to teach a course called IMCD 10, which is the last course. Definitely you're not one of my students because you're still IMCD 6. And right now I'm teaching an advanced course, CRTL. And thank you very much for watching my videos. Thank you very much. It means a lot to me, especially when Ashton students watch my videos. It means a lot to me. So thank you very much. So the next question is from Jack Randall. Oh, okay. And yeah, I agree with you, Jack. There is no need to repeat your questions because I will answer all the questions before I go. So don't worry about it. So the next question is from Jamshid Hosna. Hi, sir. My file got transferred to Poland, Warsaw from London visa office. So they are refusing spousal sponsorship applications as well. No, don't worry about it. Warsaw, the only problem that we have with Warsaw right now is just with the self-employed cases. So don't worry about anything else. And don't get me wrong, I'm not saying that Warsaw is an evil visa office. I didn't want to give that impression. I have worked with Warsaw pretty much from the beginning of my career. And in the past, I've had some federal skilled worker class applications. Everything went very well. But unfortunately, since 2018, they started refusing federal self-employed class applications. And this is something for the court to decide. It's an unfortunate, huge difference between of opinion between us and what the law says and Warsaw says and the behavior of the rest of visa offices in Canada. I don't want to go into the details of it because the case is in front of federal court, so I cannot explain my point of view on those applications, but I can tell you that Warsaw currently refuses almost every federal self-employed class application. But outside that, don't worry about other kinds of applications, okay? So it's just federal self-employed class. And that's it. So the next one is Samir. Hello, sir. I have 6 each in IELTS. I have liquid money around 300,000 Canadian dollars. I'm working as manager in grocery store. I want to buy a franchise like Dollarama or any other grocery store franchise. What program is suitable for me? Okay, so Samir, unfortunately, based on the information you provided and clearly in a public forum, I cannot offer immigration advice. My suggestion to you is that you fill out one of our forms, get in touch with us, and we actually have a special form for business immigration to Canada. I can actually share their link with you, but so many articles, sometimes I get lost. Okay, so this is you can refer to this link and fill out the form. That will be private. We will review that form. It's a very simple form, probably 5-10 questions. And then based on that, we'll get in touch with you and we'll advise whether to get in touch with one of our team members or book an appointment with me or fill out the assessment form, depending on the situation. But please fill that out and then we will let you know. Okay, so the next question, we're almost there. Oh my God, it's 55 minutes, but luckily there are only 2 more questions. So the next question is, hi, good morning. So this is from Jimisu. I hope I pronounced your name correctly. Hi, good morning. How the seasonal agricultural or construction worker could find or get employer's work permit? So first of all, with seasonal agricultural worker program, this is an agreement between the government of Canada and Caribbean countries and Mexico. So those workers are either coming from Caribbean countries or they are from Mexico. It's a government-run agreement. So they already have an agreement with each other in terms of how to transfer those seasonal agricultural workers to Canada. And they are agents in each of those countries that they are appointed by the government of the country. They select people and then they transfer them to Canada to work in Canadian farms on a temporary basis. Usually the work permits that are issued are around 7 months. But the maximum of duration for a work permit for SOP or seasonal agricultural worker program is only 11 months. That's the maximum that they can stay in Canada. This means that seasonal agricultural worker program never results into permanent residency, unfortunately. But they can come here to Canada, work, and then make money, send money back home, and then go back home. That's how it goes. So don't count. If you are not from any of those countries, then unfortunately, there are no opportunities for you. The next one would be, but with agricultural sector, we do have work permit options for non-seasonal situations. For example, for greenhouses, because they need employees all year round, then there is an agricultural work permit option that is available to agricultural workers in certain NOC codes. And honestly, you need to show that you have experience in those areas. You somehow need to get in touch with the farmers in Canada and they offer you a job. So it's not an openly promoted kind of program, but it do exist. In fact, probably the second work permit application that I had was from and then I'm talking about 10 years ago. It was a job offer by a farmer in our community that wanted to hire somebody from Honduras, and I took the case, and it was actually a success story. But again, they are limited, but they do exist. So you had another question. Where is it? Worker could get a job employment. Oh, in terms of construction, Well, honestly, I mean, the idea of a construction company hiring people from outside Canada, it's almost impossible unless they are dealing with a huge project and they cannot find employees inside Canada. It's very unlikely. They easily find employees inside Canada. They don't really need to hire people. We had some surge in hiring foreign nationals for construction sector back in 2008, for example, 2006, 2007, 2005 in Saskatchewan. We had some booming in Alberta around probably before 2020. But unfortunately, right now, there are not many opportunities out there. But having said that, you can go on job search websites. And I have an article about job search websites. You can read that article. I have not that the article, it's not important. It's the content of it that I have listed all the websites in Canada. But generally speaking, hoping that you find a job in Canada is not, uh, the odds are very low. Let's put it that way. Okay, the next question I want, and we already passed 1 hour, so it's probably, yeah, this is my last question that I will answer. So I want to say that I am married 2 months ago and my wife is on postgraduate work permit and I'm on study permit. Can I apply for a spouse work permit on my wife, but she do not have any job letter? So that question is from Sangha and Mo. So unfortunately, I cannot offer immigration advice to you because I don't know the specifics of your case. But generally speaking, if there is an international student here and that international student is studying at a DLI with a valid study permit, then their spouse qualifies for an open work permit under IMP. And there are some details in that, but I don't want to go into the details. But generally speaking, it is doable. For your case, I don't know. If you want our help to review your case and see if you qualify, please get in touch with us privately. Of course, our services are not free, but we can review it. And if we agree to sign an agreement, then we will professionally move forward with that. Okay, thank you very much for watching this live session. I will come back again next Sunday at 10 a.m. EST to have another live session. Remember that we offer 3 videos every week, Mondays, Wednesdays, and Fridays.